This channel does not promote any violence, harmful or illegal activities. All content provided by this channel is meant for educational purpose only.
We will, in the taking pendency of the proceeding, we will include OBCA, OBCB on the basis of strength of executive direction. Then, sorry, we have to intervene then, Mr.
May I say this? May I say this, Milord?
You are passing the buck onto the court.
No,
On
no,
one
we are
hand,
not
you are
saying-
saying that it is for the court. We are not being able to proceed with the
Milord,
election
no,
process.
Milord, that is not, Milord, my submission. My submission is, Milord, that your lordships have been pleased to deliver a judgment.
Yes,
Right, wrong, Milord, we have challenged it.
very good.
Now,
There
Milord,
is no stay.
there is no stay.
Very good.
Now, Milord, in the absence of stay, Milord, we couldn't have, Milord, redone the process because there is no stay. But, Milord, at the same time, Milord, because of situation, Milord, the reservation policy, whatever it is, amended before, after, Milord, has to be given effect to or, Milord, taken forward because of very many reasons. What are the reasons? One is, Milord, admissions cannot wait. Number two is, Milord,
We are not asking you. to
may
get-
I say this? May I say this?
No,
Milord?
no, why the state is so reluctant? They are saying that no. Even if you have said 66 OBCs are there, we will not do that. We will sit tight. We will conduct the inquiry. Bring more than 500 classes again entry. This is not a.
Milord, these are, Milord, in
When
all.
you are tussle, Mr. Dotto,
Milord, may I say
you
this?
yourself have appeared and said before us that don't worry, we are initiating the process. You are in CC of the matter. Let us come back with what are the developments.
Milord, please, Milord, do not consider it from that angle. Milord, my problem is, Milord, the matter is before the Supreme Court.
Mr. Dotto, why you are not willing to proceed with the appointment procedures and admission on the basis of what remains after our judgment, which has not been stayed by the Supreme
Milord, your lordships have been pleased to, Milord, formulate a process.
do it for this year. Next year,
Milord, that, Milord, we have done. Milord, our case is that we have scrupulously followed the order or the process that your lordships have been pleased to lay down, though, Milord, it is before the Supreme Court, whatever it is.
then we have a
Yes.
right to scrutinize such action on your.
Yes.
Don't
Yes.
give effect to this executive order till we hear the matter.
Just for
Milord,
a period of
Milord, could I say this? Milord,
I
Milord,
have
my giving effect or, Milord, not giving effect, Milord, please consider this, Milord. Whatever your lordships direct has to be followed.
No,
There's no
we are
dispute.
at a loss to understand that why state is so reluctant. State says that no, we will not comply with your direction. We will bring.
But
new
my
classes.
case is, we'll demonstrate that we have complied.
You will demonstrate.
Yes.
Till such demonstration, you don't give effect to this executive.
But what happens to my admissions?
What happens? 66.
Now,
classes
Milord,
are there.
please consider, Milord.
6
Milord,
classes are
Milord, I can understand, Milord, your lordships are taking suo motu cognizance. That is one thing. But
No,
Milord,
no.
yes.
Not suo motu. We are acting on the undertaking which you have given before us. You have said that, see, our order has not been stayed. We have not jumped up on you. We have given you liberty that, all right, Mr. Dotto, when you are somebody, come with this. Today, when the picture scenario is clear that 66 is untouched by our judgment, you continue this election process.
and in the event you decide that these classes that you have selected now are upheld by us or the Supreme Court or whatever, you can hold a special recruitment drive for these persons. There are always these drives that are done on a regular basis in the
Milord, may I
states
say this?
across the country.
Milord, may I say this, Milord? May I say this, Milord? Please,
And
please, please.
insofar as the admissions are concerned, there is a single judge decision which says you follow the 66 process, 60 classes then, and you also follow the roster that was applicable then. This is only pending the finalization of these proceedings. In the meantime, you have waited for such a long time. You can't wait for 2 more weeks, Mr. Dotto.
Milord, please consider this, Milord. This is not, Milord, what has been passed by the learned single judgment, that Supreme Mondol. But Supreme Mondol, Milord, is only confined to, Milord, joint entrance examination for 2024-25.
Now, for which reason we are saying, for the time being, there is an urgent need for recruitment in the state. In general, we understand that. More so, we understand the district judiciary. There has been no appointment or recruitment in the district judiciary
Right.
since 2004. There are people who are retiring every day. Our functioning of our district judiciary is seriously prejudiced and affected. So we need urgent recruitment. As the stopgap measure for the time being, the model that has been suggested by the single bench in that Supreme Mandal or whatever it is, the case, you please follow, give us a breathing space so that everybody can bring their stand on record by affidavit. You respond to their application. They will respond to your affidavit in opposition.
Madam, we have not yet used. The state has not yet used. Madam.
No, there was no direction.
There was no direction.
Yes, Mr. Chakravarti.
I have
Right.
got three things to submit. Firstly, my lord, your lordship,
So just
now the Supreme Court did not grant a stay. Supreme Court on a subsequent event allowed benchmark survey. And that being aggrieved, public interest litigations anew were filed. Then in the public interest litigation,
benchmark survey was permitted by the Supreme Court.
on subsequent questioning, they have
They have
They
submitted.
have submitted.
Supreme Court has
No,
not
they
said.
did.
Yes. Now, my lord, these four writ petitions which were filed anew, challenging the process of benchmark survey, there your lordships have been pleased to give a limited right to the OBC Commission and not to take any final decision. That is not being pressed by anyone of the learned advocates.
No, no, no.
Kindly come to paper.
That rider is
No,
not.
kindly para 17 of the last order. 6/5/2025. Para 17. This is a right to issue advertisement, invalid objection.
My brother.
এটা কোনটা দেখাচ্ছে গো?
Last order.
Page six.
Para 17. Let affidavit in opposition.
Just a moment.
Page 42 of the affidavit in opposition.
58 and করে গেছে।
এটা তুমি অন্য
Application.
না না পুরবী দাসের অ্যাপ্লিকেশনটা কোথায়?
Malaj, it is there in the affidavit in opposition,
আহা, না,
page
এটা
42.
এটা পুরবী দাসের অ্যাপ্লিকেশনটা দাও, can 1 যেটা পুরবী দাসের ফাইল। এটা পেজ
We have not filed.
Yes,
প্যারাগ্রাফ 70
17.
yes, please.
Just immediately preceding paragraph 17.
Yes.
What is the order your lordships have been pleased to pass, allowing them to issue advertisement, invalid objection, nothing more. So where is this question of completing the entire?
where is the said that
Para 17, let affidavit in opposition indicating compliance of the above process be filed by the commission
Yes.
by 19 June
we have not
2025.
stopped them.
Direction which your lordships have been pleased to pass in para 14, 15 and 16, that has to be complied with by filing an affidavit. Not to proceed anew and go further by issuing notification completing the process by 45 days, about 140 casts in an indecent haste.
That is what we are considering.
But then, my lord, there are something more for the Union of India to submit. Now, my lord, this cabinet, Government of India cabinet approved caste enumeration in connection with census. Now, census is census is included in NT 69 of list 1 of the 7th schedule. The cabinet has approved the enumeration process. Whether by or without, leaving aside the enumeration process, this system can be continued. Kindly see what is the decision of the cabinet.
If the enumeration is to take place 27, everybody will get-
27.
it will get stalled.
No. No question. of
That has the
Then
cabinet
what will
taken
be
that
done?
decision?
Then our order
Your
can.
lordship today allow the notifications to be placed before this state assembly and give approval which Mr. Dutta has submitted. What remains for adjudication either
It has
before
been
the-
approved.
either before the Supreme Court or before here. Nothing remains to be adjudicated.
My lord, I can comply with your lordship's order. Take an example, my lord. I have not challenged the order before the Supreme Court.
Secondly,
Then also, my lord, my duty was to comply with the order. I have
from the
complied with it.
affidavit in opposition, from this affidavit in opposition filed by this backward commission West Bengal, there is a direction, opinion was sought for by the chairman for the London Advocate General, and the what London Advocate General opined. Kindly see at page from the affidavit.
I have a right to opine wrongly.
This is by dictation,
No.
not by independent action.
Man,
I have a right to opine wrongly.
348,
Now
348.
that cannot be, my lord, a subject matter of scrutiny before the court.
Page 48 of the.
my lord, one thing, my lord.
That is their opposition.
My lord, may I just,
Document.
তাড়াহুড়ো করো না এখন।
Fine.
হ্যাঁ। মানে may I just, মানে if your lordship, one minute.
Kindly come to page 340.
Yeah, just give us a moment, Mr.
348 of the affidavit filed by them.
Central government is concluding on your behalf.
Don't
bother.
আচ্ছা এর মধ্যে আছে। Yes, 348.
Yes, now kindly find towards the middle. What is the letter written by the chairman of the state commission? Members have expressed their deep concern about the stalemate that has resulted due to pendency of the litigation before the court of law. How can such a letter be written? Now, secondly, kindly come to the next page. During
Which page is it? 460.
কোন পেজ পড়ছেন? স্যার কোন পেজ?
350.
ও আচ্ছা ঠিক আছে।
On February 11, 2025, you also got it. Page 350.
350.
Yes. During pendency, he also got, as you also got, during pendency of the litigations, the office of the commission received fresh applications for consideration of status that would include some of the classes whose designation given earlier had been set aside by the Honorable High Court and are the subject matter of challenge before the Apex Court in the SLPs. In such circumstances, the BCW Department of the State approached the Learned Advocate General for his opinion on the issue as to whether the state could proceed in the matter to commence survey of the communities involved in those pending applications without prejudice to the rights and contentions in the pending application. Now, 350, kindly come. On February 11, 2025, the opinion of the Learned Advocate General dated November 25, 2024 was placed before the chairman. The relevant part is extracted below. To answer the issues, the basis of the judgments of the Honorable High Court needs to be ascertained first. The Honorable High Court came to the following conclusions. The Commission did not discharge its role in the required manner, namely to collect materials by survey or other means, hear the parties, render its advice based on objective criteria and materials, etc. The reports of the Commission making recommendation were not promised on any adequate determining principle. Therefore, the entire thing is on dictation by the government of West Bengal. No independent power exercised by the commission, state commission. It has to be struck down on this issue itself.
That is a quotation from your lordship judgment.
This is their affidavit. Secondly,
My lord, may I just, my lord,
secondly,
yes, my lord, kindly allow me 1 minute.
Voice as
No, please.
Voice as introduction.
No, no.
They were arguing, I have not said anything.
Okay.
Then, my lord, kindly come. The question of Article 246, sub-article 4 of the Constitution. Whenever in a census proceeding initiated by the Parliament on an Act of Parliament under NT 69 is initiated, and a cabinet takes a decision for enumeration to be included in such proceeding, whether this abundant continuation of this proceeding and finality rests tabled before the state legislature. What remains? The Supreme Court SLP has become infructuous. The public interest litigations filed before your lordships have become infructuous. Without whether your lordships had been pleased to grant any leave to them to make a finalize the notification, place it before the state legislature, and come to a finality. An old wine in new bottle is placed again. That has been submitted by Mr. Ram, appearing for the petitioner. Third, that apart, the National Commission excluded 35 castes from the question of inclusion in the OBC.
No, what is the answered 1 and answered 2 given? Kindly come to page 353. You were proceeding on that basis. Commission asks for an opinion from the state.
The BCW department asks for notice.
Sorry, BCW.
Look, I am
Answer to issue
respectfully-
number 1.
I am
Page
respectfully submitting that this is an independent procedure initiated either by the state commission or to be initiated by the national commission for determination under the constitutional scheme under Article 338B of the Constitution.
Excellent.
It's a power. Whether a state government can dictate terms, advocacy's opinion on the basis of this can be sought for, and a proceeding can be initiated, number 1. Number 2, whether during the pendency of the SLP in regard to the challenge to the judgment pass delivered by your lordships, whether that can be made infructuous by issuing notification, placing before the state legislature. Number 2. Number 3, your lordships on the latest public interest litigation did not allow them to publish this notification and place it before the state legislature. On this ground, it has to be stayed only.
Madam, 1 minute.
Then, my lord,
we have not stopped them.
Correct.
We have not stopped them.
Your
They do
lawsuit-
not undertake any process.
your lordships have been pleased to grant them liberty to issue advertisement.
No.
No.
Yes.
We have not given.
No.
We have said that.
Mediation.
I am reading. The advertisement should spread awareness of the identification and survey to be conducted by the commission as to enable all classes and communities in the state who consider themselves or are backward to fill in applications in the format available on the commission's website or be identified by the commission.
Where
This
are
is
you?
your lawsuit order at para 14, the last order.
Paragraph 6 of the order.
তোমরা একই দিকে আছো নিয়ে যাও না
কনফারেন্স
করে এসছি দাঁড় করিয়েছো কেন
মাঝে তুমি আছো
তো একদিকে চলে যাবে
Para 14, 15, 16. The advertisement shall be published in widely circulating newspapers that they are saying they are published.
Prime officer. Prime officer.
14, 15 and 16. And
না যদি না শেষ হয় তখন তুমি ইন্টারভিউ করতে পারবে তোমার হয়ে যাবে
There is no 7-0 in schedule 2. It is entry 41.
General writer.
You are looking at list 1. 27.
ASG finished.
correct. Now, my lord, after your losses or last order on 6th May 2025, we find within 45 days, 140 casts have been decided where normally for one cast 45 days is required for survey. And what is electronic speed, indecent haste, notification pressed before the state legislature. This is malafide, absolutely malafide.
Central government saying.
My lord,
No,
my lord will hear us. My lord will hear us.
I am also appearing for the National Commission of Backward Castes. National Commission of Backward Castes, time and again. the last 3
170.
years.
How many included? 170.
Not at all. Incorrect submissions are being made.
One-
But I'm sorry to say,
117.
incorrect statements are being made.
I am not submitting included. I am submitting within 45 days after your losses order on 6th May 2025.
4 months.
140
76 with respect to 76 notifications have been issued. With respect to 41, the process is ongoing. And who is making this submission? NCBC is making this submission in view of 105th Constitution Amendment. NCBC has no role to play. In view of clause 3 of Article 342A.
Very well, let us see. Let us
Himalaya,
see.
my learned ASG was making submissions regarding 246.4. 342A3 clearly says, with regard to state list, NCBC has no role to play. This was the scheme.
Very well.
Lastly, I submit, my lord, for the last 1.5 years, National Commission of Backward Castes is
have
writing
180.
time and again letters
We have 180.
to the State Commission and to the Chief Secretary. Every time there is an action that is to be replied, nothing was done. So whether this is a question of national issue or a state list or a central list
64
or
66 classes.
scope of Article 246 sub Article 4 will play
And then
come into play
51
after enumeration decided by the cabinet
and 25
under
more
the
classes.
NT 69 or list 1 of 7th schedule. That is a matter to be decided. Now, when the learned advocate general submitted this is finality, the notifications, then it has to be stayed. Everything cannot be made infructuous by an executive action. The judicial process.
Very.
And your lordships are aware, when a judgment is delivered in a judicial capacity, judicial process, when that can be frustrated, there are number of judgments of the Supreme Court in which process, not by executive instruction, not by survey, not by issuing notification. This is patently illegal. It has to be stayed.
One.
Yes.